102. Can I lay off a substandard job performer rather than terminate for cause?
Managers who want to avoid the confrontation associated with progressive discipline and termination often look to the path of least resistance, a no-fault layoff. But layoffs aren't always the easy-out solution that you may be looking for, and you're typically better off pursuing a legitimate termination for cause via progressive discipline. Why? Because managing employee performance problems via progressive discipline holds employees accountable for their actions, establishes a performance improvement plan that actively involves your company in the employee's rehabilitation, and creates a defensible written record to show that you've accorded the employee with workplace due process. Still, many managers prefer to pursue a layoff because it lacks the ongoing confrontation associated with progressive discipline and because it appears to provide a quicker solution to ending employment. Make sure, however, that you follow the guidelines for layoffs before pursuing this option. Tell me more. First, keep in mind that in a layoff you eliminate positions, not people. In other words, your written records must reflect that a position is being eliminated because of a lack of work or other financial constraints, and the individual who currently fills that position will now be impacted because there's no longer a job to report to. If removing a problem performer is your goal, eliminating that individual's job may be a big mistake. After all, you'll still need to get the work done. If, after going through all of the considerations for a layoff, you find that the individual identified for a layoff is the person you originally targeted because of her ongoing performance problems, then you may be safe to sever her employment. If, on the other hand, the underperforming employee is arguably not the least qualified individual, on the basis of your review of all relevant criteria, including performance evaluations and other written records, then you have to lay off one of the other two secretaries. Of course, that means that a layoff is no longer a viable alternative. Therefore, you have to revert to managing that individual's performance via documented progressive discipline. But wait. There is another key consideration when determining whether a layoff is the appropriate employer action when dealing with underperforming employees. You've also got to keep in mind that courts and juries have certain expectations about employers' responsibilities when eliminating positions and laying off workers. The logic is simply this: if a company has a legitimate business reason to eliminate a position, it probably shouldn't have a need to recreate that position in the near future. If the company recreates the position soon after eliminating it, a judge or jury might conclude that the company's original action was only a pretext. In other words, the court could be persuaded that the so-called layoff was really a termination for cause in disguise. This could obviously damage the company's credibility during litigation. How long does the position need to remain unfilled? That depends on your state's statute of limitations on unlawful employment practices. In many states, an ex-employee may file a complaint up to 1 year from the date that the unlawful practice occurred. Therefore, it's typically safest to wait at least 12 months before filling a position that was previously eliminated. What if you are willing to gamble and fill the position after, say, 6 months? Well, if the ex-employee learns that her previous position has been filled and she engages the services of a plaintiff attorney to pursue the matter, then the damages sought will be similar to those in a wrongful termination or unlawful discrimination claim. If you are held to a for-cause standard of termination, you may be burdened with providing documentation to show that you had reason to terminate the employee because of substandard job performance, inappropriate workplace conduct, or excessive absenteeism. As is typically the case with layoffs, though, employers aren't prepared to show proof via progressive discipline that performance was a problem. As a result, an out-of-court settlement will probably need to be reached. Damages could include reimbursement for lost wages, compensation for emotional distress, plaintiff attorney's fees, and, In egregious cases of employer misconduct, punitive damages. Therefore, layoffs should be implemented only when position eliminations are inevitable because of a lack of work or other financial considerations. Because of their complications and limitations, they should not be used as an alternative to dealing with individual performance problems.